All rise. Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Richard P. Worfinger, Judge presiding. All persons having business before the court will near give attention and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and I'm joined on the panel today by Judge Bill Palmer on your left, and a visiting judge from the Ninth Circuit, Judge Tom Turner, on your right. We have one criminal and two civil cases today. The criminal case has 15 minutes per side. The civil case is 20 minutes per side. If the clock is set at 5 minutes for rebuttal, but if you want something different than that, let me know and I'll set it. When the light flashes orange, you're into your rebuttal time. If you have a cell phone, please silence it so that we don't interrupt anyone's argument. And we'll go ahead and call the first case, Joseph Kleintank versus State. Good morning.
Good morning.
Good morning.
May it please the court, my name is Matthew McLean. I represent Jacob Kleintank. Respectfully would request 3 minutes for rebuttal.
All right.
The state in this case concedes the third and fourth issue, so unless there's any questions directed as to either of those, I'll go ahead and direct my attention and the court's attention to the first and second issues.
Let me ask, are you aware of any case where the judge understood that he had or she had the ability to depart, considered the evidence, and then chose not to depart, that gets reversed? I've seen the cases where the judge misunderstands the law and thinks he or she can't downwardly depart. But are you aware of a case where the judge understood that he or she could downwardly depart, considered the evidence, and then made the discretionary decision not to depart?
I'm not aware of a case directly on point to that particular scenario. It's a three-step...
I'm sorry, go ahead.
It's 3 steps that the court looks at, and the first one is there a legal basis? Second one is whether there's substantial evidence for that legal basis, and the third, which Your Honor is alluding to, is in the discretion, considering the totality of the circumstances, should the court depart.
Do you think here that the judge understood that he had the ability to depart?
I don't think he did, and the reason why is, I can go ahead and say exactly what he said. I find there's no evidence to show that this mental disorder is unrelated to substance abuse. I find specifically that the problem that you have, the mental challenges that you have, are, if anything, exacerbated by controlled substances, and the most abused drug, which of course, sadly, is alcohol. So based off that, I think the court stopped at the second prong, determining, is there substantial evidence that this disorder, which is bipolar disorder type 2, is unrelated or was unrelated to substance abuse. Or
is it possible that the judge just didn't accept the fact that that was really the causal fact of his bipolar disorder, that he just thought he was a drug addict engaging in drug addictive behaviors?
Well, I don't think there was any evidence to support that. We have the expert in this case, Dr. Carpenter. He was the only expert to testify as to the relationship of this bipolar disorder as it related to the acts that Mr. Kleintank clearly committed. And he used, to me, a but-for analysis. But for this bipolar disorder, this act that was irrational behavior committed by Mr. Kleintank would not have occurred. The difference, and the state actually asked about it on cross-examination. Well, couldn't this just be somebody who's jonesing, wanting more drugs? Wouldn't they, have acted similar to this? And he said, no. The piece of evidence that is different, that distinguishes this case, is his bipolar disorder, this manic state he was in that caused him to have this grand idea that he committed this act. So we have two situations. We would have one which is a drug addict with no mental disorder, and the expert says he wouldn't have committed this crime. Then we have Mr. Kleintank, who has a substance abuse problem and also a mental disorder, and that mental disorder is the cause for the actions that he took. And I think that the judge had no evidence for his factual findings that he made. There's no consubstantial evidence to show that this alcohol addiction or drug addiction exasperated the mental disorder. There's simply no testimony for that. So the only way that the judge would have gotten there is by taking something outside of the record that was not presented to it and applying it to this case. Dr. Carpenter never testified that the substance abuse or alcohol abuse exasperated his mental disorder and caused him to get in this manic state.
Do you think that the court has to accept, anytime a person brings in an expert and says, but for his mental disorder, he would not have committed this crime, is the court obligated to accept that testimony?
I think in this case it is, because as Camacho tells us, the two steps that the court has to consider before exercising its discretion is there competent substantial evidence in support of that valid reason for departure sentence. It's not whether there's no evidence, it's whether there is evidence that they support it. In this case, there was substantial evidence that this mental disorder did diminish his capacity and that he did need treatment for it. And misapplying that standard is the cause for the court not getting to that third step. And I think remand is necessary for this case because the conclusions that the court made aren't supported by the record. I don't know. The critical testimony in this case is between transcript page 60 and 79. I've read it over and over again, and I can't find where it says exasperated. I don't know where the judge got that from. I just don't see it. This case is very, very similar to Camacho and to the Daniels decision. In Camacho, we had a boxer who suffered repeated blows to his head, which caused brain damage. The expert testified to that, and the resulting mental disorder caused him to have diminished capacity. On cross-examination, he admitted, yes, there's some indication that he has a substance abuse problem, but just because there's independent causes that would link to this diminished capacity does not mean that mitigation, that reason for downward departure, is not valid anymore. And the court should then go to that last step in exercising its discretion. But as Your Honor Orfinger was stating, is there a case that directly says, if they do reach that third step, can the court still reverse? And I think in this situation, reversal is necessary because when we look at the evidence, and the judge never said, I discredit this witness, I don't believe this witness, I don't believe that there was a mental disorder here, then we have to go ahead and correct the judge and have him understand.
Would the trial judge have done that, and then it would be not reversible?
I think, yes, if he would have made those findings that I don't agree with the experts for something that was presented to it, or that, considering the totality of the circumstances, I don't believe that this mental disorder is garnishing of a downward departure sentence, then sure. But when the court specifically makes mention that there's no evidence and that it makes up a standard that there's exasperating the mental disorder based off these drugs usage, then I don't know how we can have faith that this was fairly adjudicated case and fairly determined reason for downward departure.
Didn't Dr. Carpenter testify that he had a dual diagnosis, mental disorder and substance abuse, and they were linked all the way to the neurological level? Doesn't that make it related?
Related in the sense that, yes, he does have a mental disorder and he does have a substance abuse problem. That's the same fact scenario in Camacho and Daniels. They each had mental disorders and substance abuse disorders, but that doesn't mean that the statutory recognized reason for downward departure is no longer available to these defendants.
But what does it mean to be linked all the way to the neurological level? What does that mean?
Well, Dr. Carpenter explained it as somebody with bipolar disorder and mental disorders, they sometimes self-medicate. And when they experiment with drugs, they're more prone to addiction. And that could link to a further addiction in these people being substance abusers and alcohol abusers down the line. So I think when he said linked to a neurological level, he was stating these individuals are more susceptible to drug abuse and substance abuse because they're undiagnosed, untreated. And so they try to self-medicate to treat these very violent mood swings from a normal state to a depressed state to a very excitable, irrational state.
Also, part of the reason for a downward departure would be that this was committed in an unsophisticated manner, yet the judge did find that he backed into the parking spot. He made some pretty good plans in this. It just wasn't something that happened spontaneously after he walked into the store and freaked out.
Sure, and I agree that there is that finding that it was not committed in a unsophisticated manner is supported by the record, and they could go ahead and make that determination. But the other two factors, I think that's where the argument, the thrust we want to focus on. And this was a very ill-conceived plan to begin with. He walks into a CVS store with no shoes on. He's immediately spotted by the store clerk. He's not wearing a mask. He's not wearing anything. The TV captures it all on the security system, and then the store clerk immediately confronts him, sees him, identifies him. Can you leave the store? And then he goes to the pharmacy for the second time that day, hands him a prescription that is, as Dr. Carpenter stated, no rational pharmacist would accept, and then jumps over the counter with a knife and starts stabbing people. It's just completely irrational behavior, which, to society, I think we need to go ahead and treat these individuals differently and have the judges accept these mental disorders. And that's the reason why this statute exists for downward departures, to treat these people below the lowest permissible sentence. The second issue I just want to briefly touch on before my time runs out is the special conditions that were imposed. This court in Grubbs departed from a long line of decisions that said any written conditions that were not orally pronounced cannot be imposed after the fact. And the Grubb decision really relied on Rule 3.800B2 as curing any procedural due process that would have happened. I think there's a split amongst the districts that's occurring, and just point the court's attention to the Snow decision out of the 4th and the Parkerson decision out of the 1st. And in those cases, they both involve special conditions related to sex offender probation that were not orally pronounced. They depart and go away from Grubb and state that the proper remedy here is to strike those conditions and not reimpose them, basically what happened pre-Grubb. And interestingly, the Grubb decision, Snow decision, and Parkerson decision all cite a Florida Supreme Court case, Justice v. State. And Justice v. State says, we have to go this way, which was pre-Grubb, because it's going to prevent double jeopardy violations from occurring. We can't simply allow a court to orally pronounce sentence, go back to chambers, and then increase the sentence on its own initiative by including those conditions in its written probation order. And so Rule 3800B2 does not cure that violation that has occurred in this case. And I'll go ahead and reserve the remainder of my time unless there's any questions.
Thank you so much. And I forgot to say that we're going to take a break after the second case, and we'll invite counsel to join us in the attorney's lounge if they choose to, for coffee.
Please the court. My name is Kaylee Tapman, and I represent the state of Florida in this case. As to the downward departure, as the trial court did not apply an incorrect standard in determining not to depart, this court shouldn't even review his discretionary decision. The trial court knew that he had the authority to depart, and just simply found that there wasn't a factual adequate basis to meet those mitigating factors, and therefore refused the request for departure. As to the special conditions of probation, I would submit that the appellant has conceded that there were no substantive arguments against the special conditions, and the filing of the not one but two 3800 motions has gotten rid of any procedural due process violations pursuant to Grubb. The state would submit the thoughtful and well-reasoned opinion in Grubb, which was decided
Well, you're
on...
only saying that because I wrote it.
Maybe a little, but it was. And it makes sense pursuant to Maddox, which came out in, I think, 2000. It has never been overturned, and its reasoning stands that the promulgation of Rule 3800 gave the defendants the opportunity and notice to object to special conditions that were not orally pronounced, and that's what happened in this case. And as there were no substantive arguments, the procedural due process has been cleared, and the special conditions should not have to be struck from the order.
All right, back to your first issue, did the judge at any point say that he did not think he had the discretion to depart, or did he say, I know I have the discretion, but I'm not going to depart?
He didn't specifically say either of those things. However, he knew he had the discretion to depart. He listened to legal arguments as to whether the evidence met the mitigating factors as outlined in the statute, and simply found that the evidence did not meet those factors, that the substance abuse and the mental illness were related. I'm assuming it's because the finding of exasperation is due to the fact that the expert testified that the defendant was self-medicating to level out his vacillating moods, as opposed to going to a doctor to get real medicine, and the fact that the court also made a telling argument of that the image that he would always be left with was the image of homicidal rage on the defendant's face as he jumped over the counter to, attack the pharmacist to get drugs. And I think that's why he found that the substance abuse and the mental illness were related in that regard, and found that there was not an adequate factual basis to downwardly depart.
But couldn't that also be interpreted to say that since you haven't met the standards, I don't have the authority to depart because you haven't met these standards?
I think there's a different, by saying you haven't met the standards is saying that I don't have the factual authority to depart, by saying that there is not enough competent evidence to meet those standards, versus saying there are no legal ways that I can depart and I don't think I have that option. So I think in this case the trial court acted appropriately, and if there are no further questions, we ask that you affirm. Thank you.
Thank you.
Thank you. May it please the court, as to Judge Turner's point, you're right, there's two different ways to interpret what the judge did in this case. And that's why Camacho reversed. Specifically in their decision, they said our difficulty in this case is that we were uncertain whether the trial court's ruling was based on rejection of some of the experts' opinions, or whether it made a legal error by concluding that no legal basis for departure existed because there was evidence of substance abuse. In this same situation, we can try to interpret it, but we don't know. There's two different reasonable interpretations that we can come to. The appropriate thing would be to remand to the trial court, and if the trial court says, look, I found no legal reason to depart, then we know for sure what the answer is. But right now we can't speculate as to what that is. And aside from that, the fact that there's substance abuse and mental illness does not disqualify a defendant from getting a downward departure. There can be independent causal acts for impaired state, or even independent reasons for substance treatment, which is in the Daniels case. In Daniels, there was the need for treatment of a mental disorder and treatment for substance abuse. The court reversed, said just because they're both there doesn't mean that there's no valid legal reason there is a valid legal reason. You should go and exercise your discretion as to whether a downward departure sentence is needed in this case. Just close on the thought that the state had about this homicidal rage. And that's absolutely true. There was a homicidal rage on Mr. Kleintank's face. But you have to take it in context. This isn't some guy who was committing violent crimes throughout his life. This is a guy who had a family, he had a good job, he had a good family, and out of nowhere he commits this homicidal rage type acts, which the judge said, I'm surprised nobody died. But that's specifically because it's tied to a mental disorder that he wasn't able to control because undiagnosed and untreated. Thank you, Your Honors.
Thank you so much, counsel.